Good afternoon. This is Tammy Weber. I'm a certified elder law attorney at Marshall Parker and Weber, and welcome to our 2017 Legal Update webinar today. We're going to hit 4 topics of note that could help you if you're a professional provider, help your clients, and always remember we're here to help if you have questions. We will have a full elder law update at our 21st annual professional update on Thursday, May 11th at the Williamsport Genetti and Friday, May 12th at the Wilkes-Barre Genetti Hotel. As with any legal advice or planning we talk about, it is specific to each individual. So this is my standard disclaimer that what we say here today really needs to be followed by a thorough consultation with clients and hopefully with financial advisors and professional advisors as well. There is a question and answer sidebar, and so if you think of anything and you want to ask, please go ahead and type it in. If we do not have time and you have follow-up questions, you can do so on the last screen. So here we go. Our first topic and change is the Social Security full retirement age increase. So if you or your client or a patient was born after January 1st of 1955, there's going to be an increase this year. It impacts your client or patient's benefits and not really in a very good way. Full retirement age, and sometimes you see it abbreviated as FRA, is the age at which a worker first becomes entitled to full or unreduced retirement benefits. So we as workers have a choice. I call it the choice and consequence syndrome. You can claim benefits early once you reach age 62, but if you do choose to claim before your full retirement age, you're going to receive permanently reduced benefits. On the other hand, if you wait until your full retirement age to begin your claim, your benefits are going to be increased through which we call delayed retirement credits. This means the longer you wait for your money, up to age 70, the more you're going to eventually receive each month. The reduction or the increase in benefits, as I said, is permanent, and it's going to continue for the remainder of your life. Now, for many years, the full retirement age was 65. However, people are living longer. There were some issues with money availability in the Social Security, and so Congress, wrote gradual increases in the law. So for workers between 1938 and 1943 birth years, the full retirement age did increase in 2-month increments. If they were born between 1944 and 1954, the full retirement age was holding steady at age 66. But for people born in 1955 and after, it increases again in 2-month increments until it reaches age 67 for those workers that are born in 1960 or later. So anybody turning 62 in 2022 or later is going to be subject to a full retirement age of 67. So you're seeing the chart in front of you, and there's a little asterisk at the bottom. Those people that are born on January 1st should refer to the prior year, and if you're born on the 1st of the month, your benefit is that if your birthday was in the previous month. So pardon me. If you increase your full retirement age, as I said, your lifetime benefits are going to be increased regardless of the age that you initially claim benefits. To raise your monthly benefit, again, you want to delay claiming until you're older, but you're going to receive benefits for a fewer years. This is not something you just have a conversation with one person about and just make a choice. There's detailed programs, legal advice. We can help you with this. Your financial planner can help you with this. or you can help your clients make this decision if you are a financial planner. Keep in mind that it's very possible that the full retirement age is going to be increased again for younger workers. This is a way that people have talked about that Congress could improve the long-term financial stability of Social Security, and they're thinking about raising it to the age of 68. So of course, there's been a Congressional Budget Office study, and they estimate that a 1-year increase in the full retirement age would shrink federal Social Security outlays by 7% by 2046. I would note, though, that this is probably going to only apply if it does happen to younger workers, not those that are close to retirement. So that's the first change we're going to talk about today. The second law update is the Special Needs Trust Fairness Act. Now, this was effective just a couple of months ago, December 13th, 2016, and it provides that individuals with disabilities can create their own special needs trusts instead of having to rely upon others. The reason this was a very, very important act is there was an error in the existing law way back to 1993 when Congress first established the rules for special needs trusts. Now, one common type you might have heard of is the self-funded special needs trust, or known as D4A trust. And a D4A is really the citation to the law in which this is an available planning device for people with special needs. So the type of trust, the D4A trust, is created with the funds of the person with a disability, and it allows a person, a beneficiary, who is receiving Medicaid or medical assistance to protect some of their savings so they can use it later for critical living expenses and not lose their equally critical Medicaid benefits. When this law was first written back in 1993, those individuals with a disability were not permitted to create their own trusts. So for the past 24 years, these individuals had to rely on somebody else. So the law allowed a parent, a grandparent, a legal guardian, or a court to create these trusts. So there was, in effect, a presumption that the individual with a disability doesn't have the mental capacity to handle this part of their financial affairs. In addition to not really feeling great to these people, it's resulted in unnecessary delays, court costs, especially for individuals who want to establish a special needs trust, but they don't have a parent or a grandparent. And they wouldn't have a guardian if they're cognitively able to do things. So those individuals, their only choice was to petition the court to set up a trust. In addition to this time and expense, it was really felt as degrading to these people to depend on others to do it for them. So now these people with individuals with disabilities can set up their own special needs trusts. When you do this, they have to be concerned with prior Medicaid benefits received prior to the creation of the trust, maybe use some of this additional money to deal with that. One other thing to keep in mind is when the beneficiary or the assets have to be used to pay back the state Medicaid agency to the extent of the benefits provided. So what that means is the individual with a disability can set up this D4A trust, but the trust itself must have a Medicaid payback provision. So that means when that individual passes on, the states have the right to receive the remaining trust funds up to an amount equal to the total medical assistance paid by the state for the individual. So for example, if somebody sets up a D4A trust and it's set up as a result of proceeds from a personal injury settlement, and there are $200,000 in that trust, when they die, the state would have a list of how many benefits they paid for that individual, and if it was $100,000, the state will be paid back the $100,000, and the remaining $100,000 in the trust would go to the contingent beneficiaries, which is typically the family members or whomever of the person who passed on. So this is a really good thing. They have a slush fund, if you will, $200,000 in this trust in my example, that they can use for additional care for their lifetimes. But under the laws, the state's the first in line for the payback when they pass away. The trust has to be irrevocable, meaning once it's set up by the individual with a disability, they can't change it. And similarly, that individual with a disability cannot serve as the trustee. They would have too much power and control. So those are the requirements that the Social Security Administration has on these kinds of trusts, and the Social Security Administration does need to approve these trusts before they are set up. Now, there's many disabled individuals are competent to manage their finances. This is sort of similar to the ABLE Act. Now, this act was passed and signed by Governor Wolf last April 18th, and ABLE stands for Achieving a Better Life Experience. And again, it authorizes the creation of a special tax-free savings account for individuals who become disabled before the age of 26. Now, you don't have to set it up before age 26, but there has to be proof of the disability prior to that age. We don't have, there's some implementation going on. We don't have it yet in Pennsylvania. The Department of Treasury is working on it. But if you'd like to look, there is a website, paable.gov, that will give you some more details. The big restrictions on ABLE Act accounts that don't apply for special needs trust, one, we've mentioned already that the person has to be disabled before age 26. Only $100,000 in this account is protected against the Supplemental Security Income, or SSI, eligibility. What does that mean? If a person is receiving Supplemental Security Income, or SSI, they probably had not worked for a period of time sufficient to give them credits, and in order to get SSI, they would have to have resources, if they're single, of $2,000 or less. So if they were to set up an ABLE account, or people set up deposit into the ABLE account, you can have an additional $100,000 and still qualify for SSI. Now, only an additional restriction is only $14,000 per year can be added to the account. Now, that doesn't mean brother, sister, aunt, and uncle can each give $14,000. The individual can give $14,000, and all the people together. So it is a cumulative total of $14,000 into one account. And that $14,000 amount may change each year. Again, it's indexed according to what's going on with inflation through the IRS, and it's the same as the annual gift exclusion that somebody can give. So it's a great thing to have, but the self-setted special needs trust doesn't contain any of these restrictions, which is why another reason the Special Needs Fairness Act was a great thing to happen after 24 years. Now, IRS has been a little busy following what they're supposed to do as well. So they've issued some new maximum deduction amounts for long-term care insurance premiums for 2017. Now, if you or your client has a long-term care insurance policy, at least a portion of the premiums that are paid throughout the year for that policy may fall under the medical expense deduction. The other change, though, is seniors should understand the medical deduction threshold for those over 65 has increased in 2017. It is now 10%. Last year, it was 7.5% for those over 65. So the maximum amount that a policyholder can deduct for their payment of the long-term care insurance premiums on their income tax is indexed for inflation, as I said, is calculated by the IRS. Now, the amount that's deductible may not be the full amount that was paid. And again, like other medical expense deductions, it's only available to those persons who choose to itemize deductions and is subject to the medical deduction threshold. I trust me, we're going to have an example, so this will make sense. So first we look at the age. So the deduction for payment of long-term care insurance premiums is really tied to the policyholder's age. So here are a couple ranges. If they're 40 or younger, $410. If 40 and 50, $770, and as one ages, the amount available for possible deduction increases. So those who are paying for long-term care insurance premiums and are over age 70 can deduct up to $5,110 from their taxes. Any amount paid above the limit, again, not deductible. Excuse me. So let's look at this. When you're determining the maximum premium amount that's deductible, as with other medical expenses, a long-term care insurance premium does fall under the medical expense deduction threshold, and sometimes it's required, talked about as the floor. So as I said, in 2016, the floor was 7.5% of the AGI, or adjusted gross income, of the individual. Now the threshold has increased for the medical expenses to 10% of AGI. Okay, so hopefully we can make this sense. So look at Bob. He's a dapper looking individual. Bob is 71. He has an adjusted gross income of $50,000 a year. And in 2017, we're going to assume that he has $8,000 in medical expenses, and that includes $6,000 in qualified long-term care insurance premiums that he paid. So Bob can use all of his qualified medical expenses, including the premium. His deduction can only be for the total qualifying medical expenses above and beyond that 10% floor of his adjusted gross income. So in other words, with some easy math, and you notice that these are easy math examples, Bob needs qualifying medical expenses exceeding $5,000 per year. So the $5,000 is 10% of his AGI of $50,000. And once he does that, he can only deduct his qualifying expenses in excess of the $5,000. So in 2017, Bob has the $5,110 maximum long-term care insurance premium deduction. He has $2,000 in other medical expenses. So that came from the $8,000 total. And you recall $6,000 of that was for premiums. So $8,000 minus $6,000 is the $2,000 in other medical expenses. So it allowed him a total of $7,110 in allowable medical expenses. Then we have to look at the floor. so 10% of his adjusted gross income of $5,000, and subtract that. So in this example, in this year, Bob would have $2,110 in deductible medical expenses. So you might be thinking, well, gee, what would it have been like last year? Funny you should ask. So last year, the maximum premium long-term care and deduction was $4,870. So all things being equal, assume Bob paid $6,000 for his premiums and had $2,000 of other medical expenses. That would total $6,870 in allowable medical expenses for Bob, minus, so he's got to look at the floor from last year, 7.5% of his $50,000 adjusted gross income, subtract $3,750, he can deduct $3,120 in medical expenses. So it's $1,010 more in deductions Bob had last year than he does this year. So not a great change, as I said, for your clients. And again, the IRS was busy doing something else. Each year, they have to look again at annual inflation and look at schedules and put out whether there will be new estate and gift tax exclusions. So there are some new numbers this year. It's an increase of $40,000 from 2016. And so an individual can gift or pass free of federal estate tax a total of $5.49 million in 2017. Hooray for you if you fit in that category. In addition to that $5.49 million, you can give away $14,000 per year per person, an annual gift tax exclusion. That number did not change from last year. If you have more money than this, or you've given away more than that, the top tax rate stays at 40%. So if you pass on and you have $6.49 million, $1 million of it is going to be subject to the 40% tax rate, or $400,000 in federal estate tax has to be paid. And no one likes that. So advanced planning is really important. That being said, we might have some changes this year. The government is thinking about, or we've heard President Trump and Paul Ryan talking about ending the estate tax. I'll believe it when I see it. We don't know. Every year we hear what's going on. So it's really too soon to determine what's going to eventually happen. But this year, everybody has an additional $40,000 on their estate and gift tax exclusion. And finally, for the people who don't have this level of wealth, talk about a change in Medicaid or medical assistance. So qualification for Medicaid is important to many, many families in Pennsylvania, and I just wanted to remind everyone of the rules. So to qualify for Medicaid or medical assistance, there's a physical requirement and there's a financial requirement. Physically, the person applying for Medicaid to pay for nursing home level of care in a facility or at home under the waiver program or at the life program if they are in your area, have to need assistance with their activities of daily living. Those are ADLs, so going, getting a shower, getting out of bed, etc. So they have to need enough assistance that the Area Agency on Aging says they need to be in a facility. The second requirement is a financial requirement. So the person applying for Medicaid has to only have a few $1,000s in available resources. And essentially there's two numbers here. One is either $8,000 or $2,400, depending on the income of the person that's applying. But the big issue is, after you've hit both of those, when you apply for Medicaid, the government looks back 5 years prior to the date of application to see whether or not there have been gifts, and if so, those gifts can result in a period of ineligibility. How does that work? So the period of ineligibility, and this is the change that we've seen as of January 1st of 2017, begins when the person physically qualifies and financially qualifies. And then the government says, well, how much money has been gifted away within the 5 years prior to the application for Medicaid? You divide that by the average cost of nursing home care in Pennsylvania. That is currently $321.95 per day. And when you do that math, there's a resulting amount of days of ineligibility from Medicaid. And of course, we put here the monthly cost as well. This period of ineligibility is imposed for gifts greater than $500 in one calendar month. So if the applicant had 5 children, they couldn't give them all a check for $500 each in a calendar month. That would mean that would be $2,500, and that would be a period of ineligibility. They could, however, give away a $100 check to each of those 5 children, adds up to $500. They would have to divulge those gifts, however, they wouldn't result in a period of ineligibility. So when that period starts to run, that's when there can be an issue. Now, you can't get the benefits. You're in the nursing home. You have less than $8,000. Where are you going to get the money to pay for the care? The nursing home can't kick you out unless you have a safe plan of discharge. And so the nursing facility, understandably, is going to look to the children. So a denial could result in making your children or your heirs, if you are the applicant, liable for costs of the needed care. Now, we've done a previous webinar on this, so if you want to go to our website, paelderlaw.com, click on Webinars and Seminars, and then click on View Previous Webinars here. The one you would be looking for is Understanding Filial Support, and that will review in detail what happens if there's a period of ineligibility imposed and there's no money to pay for it. As you can see just from this brief update, the rules are very complicated. You check with us before completing any transaction or filing applications. We are the only local law firm with 3 certified elder law attorneys, and this is what we do every day. Again, if you'd like for more information, not only on the Medicaid filial support issue, but additional blog articles, you can go to our website. Now, we do have a part 2 of a prior webinar coming up, so if you're interested, a certified elder law attorney Elizabeth White and I will be doing the family meeting part 2, the family business. So this is going to be specifically aimed at the benefits of having a family meeting when a family business is involved and the different kinds of issues that can be presented in a planning technique. I don't see any questions on the sidebar, so I wish you all a good day and thank you for tuning in.